Number 74, People versus Yoselyn Ortega.
May it please the court, Abigail Everett for appellate Yoselyn Ortega, and I'd like to request 3 minutes for rebuttal, please.
Yes, you may.
Under the circumstances of this case, the non-testifying medical examiner's autopsy report was testimonial and gave rise to the defendant's right of confrontation.
Can I ask you?
Yes.
So these are difficult issues, these confrontation issues, and we're looking now at an autopsy case. What, in your view, could the people do, assuming there are the confrontation issues you identify there, what could the people do if they do not have a medical examiner available who was previously cross-examined? What type of evidence can they put in where the original medical examiner is not available?
Well, I'm going to suggest in a minute alternative standard between New York's current confrontation rule and Gerlich. But in direct answer to that question, the Supreme Court has held that if there's a confrontation error and it's testimonial and the person hasn't been shown to be unavailable and the defendant has not had a prior opportunity to cross-examine, that it cannot come into evidence.
I know, so what could they do if they don't have someone who was cross-examined before, but the original ME is dead?
Right, I think, I want to stress that both the Supreme Court and this court has said that, those kinds of practical considerations have no bearing on the determination.
I'm just interested in your view.
Right.
Under your rule, maybe this is a good way to flesh out your rule, under your rule, is there anything that the people could do in that situation to get in the cause of death and related evidence?
Yeah, I think what they could do is recognize up front that the standard should be not what this court has been advocating, or it's been holding, I should say, in the cases leading up to John, that you can take into consideration if it's directly accusatory, but which the Supreme Court, if you look at Melendez-Diaz and the cases cited in Gerlich, pretty clearly does not agree with it. I asked the court to relook at those.
To Judge Garcia's question, do you believe that a surrogate ME could come in and use an independent analysis looking at some evidence, documentation, and then give an opinion based upon that?
Not if they're using basis evidence, and basis evidence is what we talk about in Williams. If they're taking it for the truth, then the defendant has to have an opportunity to
Suppose they're not
cross-examine.
taking it for the truth. Suppose they're looking at the underlying medical examiner's report just to inform their opinion. Is that okay?
Probably not. And then the reason what I'd like the court to consider, though,
And they have to do another autopsy?
no, what I'd like the court to consider is that both John and Gerlich talk about the appropriate standard being, and I recognize there's dicta in John, but the appropriate standard being whether statements made under circumstances that would lead objective witness to reasonably believe the statement would be available for use in trial.
Okay, well,
If that's the
let's go
standard,
to that question.
Yeah.
That statement.
Yeah.
So back to Justice Garcia's question, is the autopsy report, if it had been redacted, what portion of that report under your view would be admissible? If they redact it, is there nothing according to you? Nothing in that autopsy?
Nothing. And the reason I'm arguing for the alternative standard is that because if an objective witness would know that this is likely to be used in trial, as in this case, when you have police involvement ahead of time, then the medical examiner's office can prepare for these eventualities. In this case, we had 4 medical examiners
But what if you
present
couldn't
at
do
the
that?
autopsy.
What if you're not in New York City? Then, their point is, aren't you then having a statute of limitations, which is essentially the lifespan of your medical examiner?
No, I disagree with that, because if this court agrees with the Gerlich standard about a reasonable, what you can anticipate, because the
But
medical
how do they
examiners...
do it? They have one medical examiner. You're in a small town in upstate New York. You have one medical examiner. What do you do not to have that problem?
I think that what they're going to need to do is if they have police involvement ahead of time and you have an identified suspect, they're going to need to get another medical examiner, or they're going to need to get a supervisor who reviews the work of the person who does the
And that,
autopsy.
that other
that's the
medical
question.
examiner, do they have to re-perform the autopsy?
No.
Or are there elements of the autopsy? Because my understanding is the autopsy is comprised of there's photographs,
Right.
there are some laboratory tests, then there are observations and interpretations, which could very well be testimonial in nature. Are there things that a medical examiner could look at in the pre-existing autopsy to reach their own independent
There may be
conclusion?
cases where the photographs would be sufficient for a medical examiner to make a reasonable decision. In this case, the photographs were not introduced into evidence. It's going to be a case-by-case
So
determination.
it is possible to have a surrogate examiner come in
If
and
the,
testify.
yes, if the material that's available can support a decision.
You
This
began
case-
by saying, sorry, you began by
Sorry.
saying that the error was the introduction of the report
Yeah.
into evidence. Is it also your contention that the examiner's testimony was erroneously admitted, or no?
Not per se her testimony, Dr. Ely's testimony. However, to the extent she based her opinions on findings of the absent medical examiner, for
So
example,
let's be careful about findings. A finding, for example, that there was a stab wound in a particular place that was, you consider that a finding?
yes, and particularly in this case, that it was a quote-unquote gaping wound, because that finding in the autopsy report that it was gaping was the basis of the testifying medical
So if you had a
examiner.
photograph of that wound, could a new examiner look at the photograph if the original autopsy, for instance, were videotaped?
Possibly.
Could they, if it's appropriately documented, make a record so that in the unlikely or probable event, people don't work forever,
Right.
and sometimes they do die. But couldn't there be an opportunity for another person to make their own conclusions and not violate the Confrontation Clause?
Possibly. I think it really is a case-by-case decision. It depends what kind of information is important in the autopsy. In this case, if they had introduced the photos,
But again, that's setting forth a standard, giving
Right.
guidance in the future.
Right, exactly.
So like the next case comes.
Exactly.
Here are things that you can consider.
Yes.
So it may or may not work, but there are things you agree.
I do
that
agree.
could possibly.
yes, I agree that you could videotape, you could have still photographs, you could have other technical substitutions, but I don't want to mislead the court to say that it will always be
So it
a
sounds like what
substitute.
you're saying they can't do is simply take something that contains conclusions and findings of the prior medical examiner and build off of that.
That is exactly what I'm saying, because the fact that it was gaping is a term of art, and based on the fact that the absent medical examiner characterized the wounds that way, that's what led Dr. Ely to determine that there had been twisting and turning by the child
It's gotta
during
be
the event.
the testifying medical examiner's judgment.
The judgment.
Not relying on someone else's judgment and perhaps building from there, not merely repeating it, but building off of that.
Building, as long as the defendant has an opportunity to confront those building blocks. It's not enough to say, and this is our disagreement with the, the plurality decision in Williams, that just because an expert is building on basis facts, that then it's okay for the expert to give an opinion. This court, Goldstein, clearly rejected the notion that basis facts don't come in for the truth.
But how does that square with Sean John's, no, you don't need all the analysts?
I think if you read Sean John, I think that the court held that the analysts who made the determinative findings that were necessary for the testimony in court to base the opinion on, those people had to be
But
produced.
not the 3 or 4 analysts before that. So how do you analogize that to autopsy?
Well,
So
I
what
think-
don't you need?
Well,
Like-
you don't, what this court, where it has erred, I think, in the past, and that Gerlich thought, was the notion that just because it's an observable fact that's recorded, that that's something that you don't have a right
So
to
photo could come in
confrontation
as a
with.
business record?
Say that again, I'm
Photo
sorry.
could come in as a business record?
Photograph could come in as a videotape.
So-
So following up on that,
Oh, go ahead.
Following up on that, you made a statement that the medical examiner couldn't testify about a twisting or a gaping wound. But in this case, do we know for certain that this medical examiner was relying on the report when she was making those?
We
or
do.
How? Because
Because
I don't think it's that clear in the
she-
record.
she
said
testified- I'm sorry.
She said that she had reviewed photographs, and the question was asked about the wounds. So if we're not sure, I don't know. I mean,
Right.
I think that it
She's-
isn't so clear in this record what it is. But if she were looking at photographs, then I think you would say that that would be okay if she described it as gaping. But if the only thing she was looking at was the report and the diagram with the annotations, that would be improper.
Yes, I agree with you, Your Honor, that this report, she said she relied on the autopsy report, the audio tape that the examiner made, and the photographs. The DA did not introduce the photographs of the audio tape, but there's no testimony from Dr. Ely that her personally determined that these were gaping wounds.
And that's the reason why you know, to go to the first part of Judge Singas's question, that's the reason why you know that that was not her own independent conclusion, because...
That's what I'm basing it on. Can I briefly talk about harm? Because I think harm is going to play a big role in the discussion. Based on the gaping characterization, the medical examiner said that she talked about her conclusions about how the crime took place, and that one of the victims had twisted and turned. Now, the respondent in their brief on page 11 acknowledges that Dr. Ely's conclusions, and I'm including in that her conclusion that she twisted and turned based on the report that it was gaping, that these conclusions, quote, provided support for several of the prosecutor's arguments against defendant's insanity defense. So that's one thing the court should consider.
Is that your argument as to why
That's
this
part of my
wouldn't be
argument.
harmless error?
Right, that's part of it. Another focus point should be that the deliberating jurors explicitly asked for the non-testifying medical examiner's annotated diagrams.
But how does that testimony undermine the insanity defense? How specifically?
Well, for example, the gaping wounds that led to a determination of twisting and turning, the prosecutor in their cross-examination of the defense expert witnesses said, doesn't that show that she was acting with intent? And they
But
said,
she could have still been acting with intent. She said, yes, I wanted to kill these kids, but I was acting because the devil told me to do it.
her
So-
defense, according to the doctor,
So
was
I'm not sure how the gaping wounds undermine that.
because the people really focused on, the people's experts said, we could see various things that happened that day, and based on those things, we determined that she was not acting in a dissociative state. And the defense experts said she was psychotic, depressed, and had hallucinations, and that the dissociative state was a coping mechanism that a person, when they're
But
to
you
fight
don't
off.
just focus on one part of the evidence. You look at all of the evidence that was supporting one conclusion or another. The burden, of course, was on the people. Didn't the people have other evidence here?
Well, the
that
burden of
one
proof
could
of-
argue that it was overwhelming evidence?
The burden of proof on the insanity is the beyond preponderance on it's an affirmative defense. I argued that when you have two expert witnesses, Dr. Resnick had 40 years' experience at the head of a forensic clinic in Ohio. You had doctors at the hospital who said she was psychotic immediately after the crime, and this is the operation of a mind. This is a difficult thing for jurors to understand, and under these
Jurors
circumstances.
can also consider her lifetime, whether she had psychotic breaks during her lifetime.
It's all
Whether
relevant.
she was hospitalized.
Yes.
What were her actions on the day in question, leading even up to, right before the children.
Right, and it's the leading right up to that I want the court to think about how the medical examiner's opinion about the crime itself, whether it did or didn't shed light on her insanity. And the other thing I want to mention is that the prosecutor, the trial
What about
prosecutor.
an objective witness that claims there was interaction with her before she went up to the apartment?
There was, yes, there were things that happened that the people's doctor thought disproved insanity. But the two experts who testified for the defense viewed that same facts, and in their, to a degree of reasonable scientific certainty, they said that did not disprove
And what about
insanity.
what she did with her precious
Right.
belongings?
I
prior
really have
to?
the same answer to that. I think there are a lot of facts in this case that could go either way. I'm not saying those aren't relevant. I'm just saying that expert witnesses weighed all these facts. And the final thing I do want to point out is the trial prosecutor really found important this characterization of the child twisting and turning that comes from the medical examiner relying on that report. That was kind of a phrase that was used in summation. That was a phrase that was used in cross-examination. I submit it's a very graphic, maybe even heartbreaking phrase. And even if it doesn't directly go to the insanity defense, that opinion given by Dr. Ely, based on the absent Emmy's testimony, was very significant to the jury's deliberation about what happened in this case. It was very prejudicial, and for that reason, I would ask for reversal, in addition to the other points raised in the brief.
Thank you.
Good afternoon, Your Honors. Dana Poole for the people. What we have here is not a case in which the jury was asked to rely on an autopsy report. This is not a case in which the people's expert was called to parrot.
So was it testimonial?
Arguably not, but what we have here is an expert who is coming up with her own independent conclusions,
But
expert
why do you need
opinions.
the notes on the diagrams then? If it's an independent conclusion, why put the exhibit in that not only has a sketch, but it has notes from the prior examiner, and then they're read in part, I think?
I don't believe they were read, she used that as a demonstrative aid in lieu of bringing the autopsy photos.
What's your best evidence in the record that she was drawing her own conclusions and not just parroting testimonial aspects of the autopsy report, assuming there are some testimonial aspects?
She specifically said she had reviewed the materials, the dictation tapes, the autopsy report, and the photographs, and using those had reached her own independent conclusions. She was asked,
So you just have to say the magic words, and then you get, and if it just so happens to be exactly the same as what the medical examiner who performed the autopsy said and concluded, that's just what happens sometimes?
well, what happened here is that the raw data that she's working off of, the photographs, the tapes, the report, all of that is turned over to the defense.
Okay, but
They-
is that admissible in and of itself?
The report, or,
The
I mean, the
various-
photographs definitely don't come under Confrontation Clause issues. Now, in this case, they were not put into evidence because they are incredibly disturbing, and there's really no dispute in this case about how
There
the
was no
children died.
stipulation from the defense lawyer as to the diagrams, right? I mean, there was no
No.
exchange, we don't put the photos in, you stick to the diagrams. right?
No, there's nothing in the record that says that, but that's the way that they were used. And there really is no dispute here about the wounds that the children received. The cross-examination.
But what is at issue is the fact that the prosecutor argued that it's sort of to disprove the insanity defense, that this showed intent, which, according to the argument, undermined the fact that this was, an act of somebody who was incapacitated, mentally incapacitated through insanity.
So that was a very small portion of the rather long summation argument in this case.
But the note that asks the court to explain consciousness versus understanding seems to suggest that the jury was grappling with that, because one goes to the definition of the act, and the other goes to the definition of the defense.
Right, so the real dispute in this case was the defendant's state of mind. It was not who caused the death or how the death was caused or what the wounds were to the children. It was the defendant's state of mind. And what the people brought in regarding that information, what they relied on were her actions
So
around.
what about the defense saying the emphasis on the gaping stab wound and how the children or child was stabbed somehow goes to whether she knew what she was doing or if she was in a disassociative state?
Well, It has very little bearing on it, because as Dr. Eli testified, she could offer no insight into the operation of the defendant's mind.
So then, you disagree. Can I ask a two-part question and follow up to Justice Duffy's question? Do you agree, first, that there is a difference between proof of intentionality and proof that tends to show whether or not the defendant understood the nature and consequences of her actions? And if you do agree that there is a distinction, is it in fact the case that the prosecutor here used autopsy evidence directed towards the NGRI defense and not intentionality?
What the argument was that you know that the defendant was acting, and again, this is a very small piece of why we know that she acted intentionally and she appreciated the nature and consequence of her actions. Because what was really at play there were all of the activities leading up to that moment.
But that goes to proof of the crime, right? It doesn't necessarily relate to the defense, or am I misunderstanding? Intentionality is the prima facie case.
Right, there are two distinct questions, but they are in many ways interlaced, because there's first the question of, was she acting with intention when she killed those children, and we proved that. And then there's the rebutting the defense evidence that she did not appreciate the nature and consequences. So a very small part of the argument was, yes, you know she was acting intentionally, and she understood what she was doing. And in this case...
And that argument was using part of the testimony of the expert that indicated that the younger child, the purposeful act to the younger child was as a result of the experience with the older child.
That was the prosecutor's argument. That was not Dr. Eli's testimony.
No, that was the prosecutor's argument, relying on that testimony.
Right, and so what the prosecutor did was posit the possibility that defendant had struggled with the first child and so caught the second child by surprise. You could easily flip that and say that it proves the same thing. There's almost no way that someone can manage to kill two children in a very small room with kitchen knives and there not be a way to argue that it shows intentionality and that she understood the nature and consequences of her acts.
But assuming the autopsy was erroneously admitted or testimonial portions, doesn't that just sort of make out the error? If that was used to negate her defense.
The autopsy report itself was not used for that. The only part of that was actually published to the jury were those diagrams, and those were used as demonstrative
That goes
aids.
back to Judge Signus's question, because it's very hard to distinguish here what was independent opinion by Dr. Eli and what was very similar content in the autopsy report.
And I think, Your Honor, that comes from the fact that these issues weren't actually in dispute. Because this is a case, again, where nobody is really disputing the nature of the wounds to the child. I mean, even without Dr. Eli's testimony, we have testimony from the first responders that the two children were all but decapitated.
A confrontation was at issue. I mean, the defense raised it, and I think what's troubling is that the imprecise language that was utilized during the direct examination of the medical examiner. It's very hard to read this record and try and figure out what is based on her own independent observations, looking at photographs, reviewing the documents. And, you know, for pages, she goes on describing the wounds after the diagram has been shown to the jury and published. And she routinely goes through that and then talks about the torso and then talks about the hand. And I mean, I don't think it's common sense to think that she committed that to memory. So she was looking at something, and the question there is she allowed to do that?
I think she's allowed to, the autopsy report is one of the kinds of materials that experts in her field use to reach their expert opinions. So it's unquestionably, she can rely on that.
Again, but there's a difference between relying it to inform her independent expert opinion and parroting what the previous medical examiner wrote down in his report.
Even if that should have been made more clear, or even if she should have dialed back any of those explanations. But again, she had seen those autopsy photographs. She could make the determination of whether those wounds were gaping or notched, how deep they were, whether they affected blood vessels or bodily organs.
But the problematic issue with the report, or maybe not according to your adversary, who contends the whole report should have come out, but there's opinion in that autopsy report, and that went in. And even though it may not have been published to the jury, that was part of your argument, it still was information that's not clear what was relied upon by the expert.
Right, and again, what we have is a situation where that particular issue is not being developed primarily because it's not the true issue in the case. Nobody is disputing the kinds of wounds that those children suffered. And again, the defense
But when
had...
the prosecutor uses that to argue that this shows that she understood the nature and consequences of her actions, it really does go to the issue in the case. I get that she didn't dispute that she stabbed the children. She might have even been willing to concede that there was an intentionality around it, but she did definitely argue that she didn't understand the nature and consequences of her action. But that's exactly what the prosecutor used this evidence for, albeit briefly, as you
Right,
said.
but the prosecutor's main argument is you look to everything that came up to that. The fact that she left her keepsakes for her son, she left the documents for her sister, she used her phone to contact her son that morning and then got rid of it. She was able to show up to work on time. She took Leo out of the apartment like she was supposed to. She picked up Leo.
But the problem is that the focus is on what was the defendant's state of mind at the time of the act, and albeit brief, that was what was focused on in that summation.
Right, but her state of mind is informed by the fact that she took all of these steps to get to the point where she could kill those
Sounds to me like you're
children.
arguing if there was an error, it was a harmless one.
Absolutely, Your
Is
Honor.
that what you're saying?
Absolutely, yes. Because this is a case about the defendant's state of mind. It is, her state of mind is shown by the fact that she, for the first time, didn't take those children where they were supposed to be. She distracted them with ice cream. She walked them around the neighborhood. And she waited until the time that she knew the mother would have left. And she came back to the apartment building and she ensured that they left, speaking to the doorman for the first time ever to ensure that the mother had left. He said, yes, the mother left with Nessie, and that is when she took the children up to the apartment. She took them to the furthest room from the front door. She brought in 2 kitchen knives, and she killed those children. She laid their bodies out neatly in a bathtub so that their mother could find them, and then
So
she
that-
waited.
Those issues all go to intent.
They do go to intent,
So
but
how do they go to her state of mind at the time of the act?
because she had planned those actions. This was not some dissociative state where all of a sudden she had no idea what was going on.
So you would agree that the issue of her intent was used to try to disprove the defense?
Well, there's 2 things going on. So it is the people's burden to prove her intent. So that we did. And a lot of that same evidence also demonstrates her capacity to appreciate the nature and consequences of
Right,
her
which
actions.
you have to disprove, assuming that they established it by their burden, you have to disprove by, beyond a reasonable doubt.
It is their burden. We can rebut their evidence, which is precisely what we did here. And what we showed is all of these steps that she took. She understood precisely what she was doing. And however you argue about what happened in that bathroom, the perseverance it would take to kill 2 children with that much lethality is indicative of her intent and that she understood her homicidal acts.
So is it your position that the autopsy report first did come into evidence, but it wasn't published, correct?
Correct.
So absent Dr. Eli's testimony, or you're not even arguing about her testimony, there's some of it, the report, absent the report, overwhelming evidence established both the intent and the ability to appreciate her.
Absolutely, Your Honor. This is a case, that even if Dr. Eli had never testified, if there was no information about the autopsy, it was clear that the defendant here intentionally killed these children and understood precisely what she was doing. And we know that because of the steps she took leading up to it and the steps that she took waiting for the mother to come home and only trying to escape the personal consequences of her acts by stabbing herself in the neck.
And that none of that could reflect that she felt there was a demonic force at play.
Well,
I'm not sure how that, what you just said, addresses that part of her defense.
Well, because what the defense was not merely she succumbed to these command hallucinations. What the defense was that she, in that moment, went into a completely dissociative, psychotic state from the time that she was in the bathroom. She was not in that dissociative psychotic state leading up to the bathroom. And there was even testimony that she was conscious and aware when the mother came and opened the door. So it's not just a matter of succumbing to those voices.
Okay,
It's
your
a-
white light is on. I'm sorry. I was wondering if you could take a moment to address the CPL 31030 jury instruction issue?
The instruction regarding the two
Understanding,
prongs.
yes.
Yes, so courts are routinely asked to adhere to the CJI instructions, and that's what Justice Caro did here. He gave an accurate description of the law, and he amended it to comport with the defense, which was they were relying on the nature and consequences solely.
Didn't the judge say he anticipated that they would come back and ask for further clarification, which seemed to me a bit odd?
Well, that was in response to the note asking for the legal definition of conscious. And so and that's when the judge said, yes, there is no legal definition. It has its ordinary meaning, aware, as does, they'd also asked for the differentiation between conscious and understanding. He said-
Understanding.
Right, so that had to do with their understanding of the instructions. And at that point, the judge said, if it would be helpful for me to reread the charges where those words are used, I'm happy to do that. The jury did not ask.
The judge, well, perhaps I'm misunderstanding the point here. I thought the point was that the judge was incorrect to say the term understanding was based on common sense.
The term understanding, yes, the judge stated it has its common meaning. There is no legal definition of understanding.
The judge had given a definition, had the
No,
judge not? Okay.
the judge,
Before
there
the
being-
note, I mean in the original charge.
In the original charge, it's that some understand, when to be able to know and appreciate
Yes.
means having some understanding, meaning more than surface knowledge. So understanding was actually part of the definition of the phrase know and understand. Yes, know and appreciate, sorry.
Yes. So is it the people's position that anything that a surrogate ME relies on to form an opinion could then be entered into evidence?
Not necessarily, Your Honor, and I don't think it's necessary that be the case here.
So what do you think could be relied on?
Her testimony. She can rely on the materials that experts in her field routinely rely on, and that's
And put them into evidence?
not necessarily. She does, for instance, in this case, the photographs were put under a sealing order so that they would not be made public. They were shared with.
And you think it's proper for the original ME's report to go in, and that does not run afoul of Melendez-Diaz or Bullcoming?
Autopsies are a little bit of a different animal, and we don't quite know how the Supreme Court would rule on those. And in this case, what you have with the autopsy, so you have the report, which is near contemporaneous documentation of data. You have the tapes that are contemporaneous recordation of the data, and you also have the photographs. And so the second, Dr. Eli in this case, the testifying ME, could rely on all of those. They don't necessarily have to come into evidence for her to be able to rely on them. And that would be similar to the Goldstein issue, where the hearsay that the psychiatrist relied on could not come in, but this court found that her testimony, the opinions that she had formed could come into evidence.
However, the closer the opinion is to relying on the underlying hearsay for the truth, the more problematic it becomes, correct?
This is sort of where this case is a little bit unique because there's really no dispute.
Right, so under other cases where the cause of death may be at issue,
Right.
that becomes problematic if there's testimony as to what the cause of death is based on what is reliable hearsay.
Well, and that can, the expert is allowed to rely on evidence that is relied on by experts in her field. And so that all it.
As long as there's also direct evidence and not just hearsay.
Yes, I mean, I think, you would have to have a body, for instance. And here we have plenty of evidence of the death, the means of death, the manner of death, the cause of death. And there really is no dispute. So to the extent that it may be hard to parse,
So you agree with your adversary that this is a fact-driven determination, which I think in Williams, the Supreme Court was concerned about, or at least Kennedy was concerned in the dissent.
well, what is true throughout, even the dissent in Williams said expert testimony is fine. The dispute is about the document. And in this case, the hearsay from the document, because the document didn't actually come into evidence. So to that extent, then the question here would be, probably in a different case, is the testifying Emmy relying solely on that document, or does she have other things such as the photographs where she can see the measurements and she can see whether it fits the description of gaping or notching or any of those other sorts of things. Here, where there's almost no dispute about any of those underlying facts, that was not explored, but it could have been because the defense had all of the raw data that the expert was relying on.
Thank you.
Thank you.
The question about whether or not the basis, I believe that was your question, the jury could be told about the facts that the expert relied on. I think Goldstein makes clear that this court finds that if a psychiatrist is going to talk about her opinion being based on interviews with other friends and families, that raises a confrontation issue. And this court in John said that those facts, addressing Williams, said those facts as the basis for the expert's opinion only are useful if they're true. So they're coming in for their truth, and they raise confrontation issues. I would also we talked, and during the DA's argument, I believe that the people are conceding that the testifying doctor's testimony was used both partially to establish intent and to rebut the insanity defense. That seemed pretty clear. The other thing was, Judge Rivera, on your question about the answer to the jury note, the prosecutor just now talked about the value of the CJI instruction. The CJI instruction regarding understanding specifically says that you define understanding as more than surface knowledge, and the CJI instruction includes that hypothetical that children can know, but do they really know? They have to, what they're doing. So that it was part of the CJI definition of these terms. What the judge did when he answered that jury question was say, no is aware, and otherwise he's have their common understanding.
Are CJI charges mandatory, or does the judge have the discretion to shape the charge based upon the case before it?
They're not mandatory. However, there's a lot of language in cases, I think for this court as well, saying they're highly recommended. And in this case, the judge did give the CJI charge, and when answering the jury's question, by omitting the full definition the judge gave originally, and when the judge said to the jurors, those terms are used in my discussion of the crimes. The judge did not say to the jurors, there's more definition of those terms in my main charge, which might have prompted the jurors to say, well, give us the rest of those definitions. What the judge said was those terms are used in my discussion of the crimes, and I will, if you want me to reread the elements of the crime, I will do that for you, but nothing by that offer.
But it's not unusual after a jury's been listening to a charge for over an hour originally, when they come back, they don't want the judge to repeat the whole thing.
I don't think they wanted the whole thing, but they did want the part of the original charge that bore on the definitions of know and understand. That's what they asked about, and that's what the judge did not repeat, what originally was in the charge and what the CJI includes in the model charge, and that was specifically objected to by defense counsel, and the judge
What
acknowledged
was specifically objected to by defense counsel? Because I have an
that
awfully
you,
hard time
that you
understanding what
didn't,
happened there.
that you didn't include in your answer to the question what you said originally, which was knowledge is more than, quote, surface knowledge, and the defense lawyer specifically said to the judge, and you didn't include the hypothetical about children and their kind of understanding. And the judge said to the defense lawyer, I agree, that they may still have questions, and I predict that they'll come back and ask for more, but they didn't come back.
And then didn't he say, if I have to, I'll reread the charges to them?
That was the point I was trying to make earlier, and I don't think I made it clearly. He said, I will repeat the charges, but he didn't say there's more definition to these terms in the original charge that I did not provide to you. That's so, the judge didn't say there's more here. He said they have their common usage. He didn't say they have their common usage. He didn't say that the definition of these, I explained further in my original charge, and I will explain that further if you want it. I think that's a significant distinction that I'm trying to make.
Why, I'm not, this is what I'm saying, it's odd to me, the jury is saying, give guidance on the difference. Why is it a half answer? I was not understanding what went on here, perhaps you can help
I
me.
don't know why it was half-answered. The
When he's
defense
saying, I predict they'll come back and say they want further clarification.
Is your question, why didn't they come back if that's what they wanted?
No, well, I don't know why the jury's not coming
Right.
back. But it just seemed to be an odd thing for the judge to say, I predict
I thought it was very
this
odd.
is not good enough and they're going to come back and want more.
It was very odd. The judge seemed to recognize that the answer that the judge provided was inadequate. And yet, he kind of shrugged his shoulders and said, oh, they'll come back and ask for more. But they didn't. That
Thank you,
doesn't mean
counsel.
that they got the right answer. They just didn't know there was more to get.
Thank you.
So I ask the court to reverse the judgment.